Hello, medievalists, and thank you for asking me to speak in your What Every Medievalist Should Know About series. My task is to give some introductory thoughts about what every medievalist should know about law. I've sneaked in the word common, you'll see, just because essentially 30 minutes is not really enough to go further afield. But I am happy to do a bit of that, talk about other systems insofar as I know anything about them, in the question and answer session at the end. I'm going to start, perhaps slightly controversially, with a source from the 19th century. It happens to be something I'm working on at the moment for other reasons, but it seemed a good place to start to get into our subject. This is a book, a treatise on the law of adultery and bastardy by Sir Nicholas Harris Nicholas from 1836. It's not a very exciting graphic, but that's what it looks like. He is not one of the more famous 19th century legal historians. He was, and I had to look it up, I'm afraid, a non-practicing barrister and an antiquarian. He has a few other books in the legal classics section of Hein Online, but this is probably the one that people look at the most frequently. And if it's not obvious what adultery and bastardy is, it's the area of law which deals with the possibility of declaring illegitimate a child which is produced during the course of a marriage or shortly after it. Nicholas goes through various medieval cases on adultery and bastardy in order to make a particular argument about what's gone wrong with the law in his age. And one of those that he mentions has the snappy title of Yearbooks Trinity 43 Edward III, Plea 5, Folio 19b. And we're going to spend a bit of time with that particular case during the course of this talk. It happens to be one of my favourites, I have to admit. Nicholas describes this as a disputed dower case, so a case in which a widow, in this case Joanna Tirrington, is claiming rights in some land which is currently held by the Beechams, John and his wife Joan. The case is made against her that she shouldn't be able to have her dower rights in this land because she's disqualified in bringing an action in dower because she eloped with an adulterer and was not reconciled with her husband. And that indeed is a possible way of opposing somebody's dower claim. Nicholas accepts this as truth. He accepts that she did actually elope. And furthermore, she became pregnant as a result of the adulterous liaison that he thought had happened. In his account, as in much else in his book, he's really focused on one of the two existing sources, I suppose the more easily available one, which is the law report, this thing with YB at the front, the yearbook, of which more later. And he's also somewhat indebted to the mediation of an early modern legal luminary, Sir Edward Coke. But if you look at both of the existing records, the plea roll, the thing with CP40 at the beginning of it, and the yearbook, you'll find that he got things a little bit wrong. And I forgot my graphics. Picture of the plea roll, picture of the yearbook. Plea roll in Latin, yearbook in French, and we'll think a bit more about that shortly. Nicholas is right that it's a dower case, and there is pleading relating to adultery. There is some talk of potential illegitimate offspring, but in fact, the story which was accepted was that Joan Tirrington was not. She didn't run off with the adulterer. The alleged adulterer in this case was called Roger. So she didn't run off with Roger. In fact, Roger abducted her after having beaten up her husband really very seriously. So her husband dies just a few days later. So it's accepted that's what happened. So she's not ousted of her dower action. And as for talk about the child, that seems to be entirely hypothetical. So it comes up in the yearbook, in the law report, that is to say, but it's not there in the plea roll. So it doesn't form a real part of the case. And that's a bit unfortunate for poor old Nicholas, because that's the whole point of talking about it as far as he's concerned. He's interested in this issue of adultery and bastardy. So is that child illegitimate? In fact, there never was a child. So you might think 19th century antiquarian misinterprets medieval source. Perhaps that doesn't seem to be such a big deal. But from my point of view, it serves to introduce us, I think, to three things I'd like to talk about today. First, it takes us, if a little obliquely, into the world of the medieval common law, a professionalised, masculine, arcane world. Secondly, it alerts us to the existence of different sorts of common law record, at least some of them. I'll talk a bit about some others in a moment. And thirdly, I would like to turn to think about the particular distortions visited upon common law cases as a result of them being considered part of a living body of law. So here Nicholas is using the case, or misusing the case, as part of an argument about law in his own time. So he's looking at where the law has gone wrong, and he's looking back to the medieval situation as he thought it was, at least. And although there are time-travelling interpretation revision issues for all sorts of historical document and all sorts of historical event, there are some extra dimensions, I think, to this as far as the common law is concerned. Some special weirdnesses which perhaps you need to bear in mind if you venture into the common law. So by the time of Tyrrington, the common law is a professionalised world. People are making a living as common lawyers. It's not just an occasional thing. The common law is training its own people. It's distinct from university training, and it's distinct from the church as well. In the 13th century, there was a stronger link with both of those things. It's producing its own literature. So the yearbooks, as mentioned, are produced by lawyers themselves. The profession is more or less two-branched. So there are people who are high-level advocates, and from that group of people, judges will be drawn. And the lower level is attorneys, who perform more basic functions. They're client-facing, if you like, as modern solicitors would have it. It's a masculine profession. It's a big clunking point to make, isn't it? Not surprising to you. It's often overlooked by legal historians who get very excited about the rise and the triumph of the legal profession. But it's important to bear it in mind, isn't it, that professionalisation is not without its downside. It excludes some people, and some of the people who are entirely excluded until the 20th century are women. It is arcane, perhaps deliberately so. So in order to be a common lawyer, there is a long path of training. You need to be on top of Latin, which is probably not so surprising. You also need to be on top of this strange, ossified version of Anglo-Norman French, which comes to be known as Law French. You need to be able to plead. So there's a whole complex series of rules about what you're allowed to say, how you're allowed to make points, what you must do to answer points. Tyrrington is a civil law case, so a non-criminal case, and perhaps that area is more complex in terms of pleading. But there are similar rules in criminal cases as well. The common law is very self-consciously different from other systems. In particular, in this case, there is a little remark which shows the common lawyers differentiating themselves and their system from canon law. So the lawyers emphasise that the rules on adultery and bastardy are different in church and common law systems. So if there had been a baby in this case, so the lawyers say, after Joan Tyrrington had eloped, if she had in fact eloped, the church would say, the canon law would say that that was a bastard, and the common law would say that as long as the husband was in the same country, there was a presumption that the child was the husband's. So that's actually correct. That was the distinction which existed at that point. And it's very interesting, but I think we'll have to leave it for now. But the point in talking about it here is to show this difference which is being made. So even though, as I say, this was a hypothetical, they're taking the opportunity to say there's a difference between canon law and us, And it doesn't actually say this, but the implication, I think, pretty clearly is, and we are better. Right, this is not an ill-advised attempt by me to do some art history, which I'm entirely unqualified. It's just making, continuing that same point, the view of the settled, exclusive nature of the medieval legal professions. So here it's a little bit ahistorical. This is from about 100 years after Tyrrington, but it's a lovely scene, and we don't have very many of them, within a courtroom, showing people's functions denoted by their dress. So at the back we have a row of judges. Towards the middle we have two gentlemen in um, robes which are blue and green, so parti-coloured robes. Those are the sergeants, so the top end of the legal profession, the part of a small body of advocates appearing in court. This is actually the Court of King's Bench, but you would also see them in other central courts at Westminster. And it's kind of the law that you have to use this picture whenever you talk about medieval common law. It's a very famous part of a set of 4 images featuring the different courts at Westminster. Okay, I think it's important to talk a little bit about the different sorts of medieval common law record and their little foibles. I've hinted at, or maybe assumed knowledge of this to a certain extent, but let me be a bit more explicit. Again, I'll do it partly through the medium of that case, Tyrrington. So the central document types relevant to a medieval common lawyer were probably treatises, statutes, plea rolls, law reports, and I stuck in there on the slide as well procedural books. I don't propose to say anything about those. Very important, very dull. By 1369, at the time of Tyrrington, the age of the great treatises, the kind of all-encompassing, this is the whole law, books, was over. So names you might know would be especially Glanville and Bracton, but also Fleeter and Britton, their kind of imitators. And they were creatures of, in the case of Glanville, the late 12th century, in the case of the other 3, the 13th century. And none of those would actually have been relevant in Tyrrington for a number of reasons. One reason is that the operative law in the case was from a statute which was a bit later, from a statute in 1285. The Statute of Westminster II, chapter 34, no less, which I have put on there, the relevant bit of it. Statute then was certainly relevant, but it's a bit of a false friend, statute. The way in which statute was handled was not settled as it would be in later centuries. So perhaps this is more of a problem for law students learning history than it is for medievalists. But interpretations of statutes is loose, it's not particularly definite. In modern times we have kind of rules about this, how you interpret a statute. One of the big issues in Tyrrington was a disagreement about how you interpret an and in this particular line. So the statute says that a wife loses her right to dower, or to the dower action more specifically, if she leaves her husband and lives with another man. So does that mean that it's enough to plead that you've not left, in the sense of you haven't gone willingly, or did you also have to deny that you'd lived away? That one in fact ran for 500 years or so. There are other cases on that down to the 1860s. I think that time is against me in terms of saying very much about the pictures at the bottom there, but perhaps during the question and answers we could explore this a little bit further. What I would like to say to medievalists generally is there's an awful lot which is rather unplumbed, both in terms of artistic or at least representational images associated with legal documents. So the pretty statute from a statute collection in the 15th century that's probably not news to you, and certainly people have looked at the images and the iconography on those sorts of things. But what has received less attention is, I don't know, is it even art? Kind of board doodles at the bottom of pages anyway. There's some work on that, but I think that's a really plum thing that somebody should have a look at. I find those sorts of things amusing and charming. I'm sure there's a lot more that I should be seeing in them. Anyway, I think that's all I can say at the moment. We'll have that in the question and answers, I hope. As mentioned, the two sources in Tyrrington, two main sources, are the yearbook and the plea roll. So here's a bit about them. The yearbook, as we've seen, is a report by lawyers, and the lawyers who make these reports are, at this period, anonymous. We've got no idea who it was. And it's worth noting that by no means all cases get this treatment. So they're selected cases which lawyers think have some particular interesting point for their education or their instruction. So from the yearbooks they could learn about legal argument, which kinds of lines of argument would work, which wouldn't, and about courtroom demeanour as well. They have, if you think about them as play scripts, sometimes they have what do you call those, stage directions, that somebody laughed, somebody made a gesture, that sort of thing. It's really important to understand that they're not trying to be accurate about facts. In fact, they're almost heroically inaccurate about facts. So you don't get names or not accurate names in yearbooks. And you don't get geographical specificity either. I wonder myself whether that's a deliberate tactic. So if you look at yearbooks, you really get the impression that the common law is the same everywhere in the country, even if perhaps it wasn't. So as a matter of fact, Tyrrington is quite central. So it's the facts are in Warwickshire and Bedfordshire and a little bit in Southwark. So it's not anywhere particularly controversial, but when you have cases which are on the towards the Welsh border, for example, where that might in fact be a factor, it's still treated as if it could be anywhere. So that's an interesting thing to speculate about, I think. Anyway, the point is that they're not trying to be documentary records of any particular case. They're instruction for lawyers in what works in court. They also contain some colourful content. So they have jokes, even if humour doesn't always work down the ages. They have proverbs, they have hypotheticals, as we've seen with the baby in Tyrrington. Plea rolls are more formal documents. We would find those in the National Archives or beautifully scanned by a project called the Anglo-American Legal Tradition, which is a wonderful thing for all legal historians. We have them from the late 12th century onwards. They are often terse. The Tyrrington report is quite long, actually. The record, rather, is quite long. And they tell us about stages of litigation, the formal pleas that are made. The yearbook tells us about the ideas that were tried out. So not necessarily the ones which were made in the end, the arguments which were made in the end, but we see lawyers trying to come to the issue which will be decisive. It's relatively rare to have both a yearbook and a plea roll. It's one of the things I enjoy doing, matching them up, but it is relatively rare to have both because of the selectivity of the yearbooks. But it's really instructive when you do, because you can see the differences between the things which are noted down. And I just wanted to go through a little bit what you might find in each of them. So if you want personal factual details, you need to go to the plea roll. You can't expect them to be in the yearbook. They might be kind of echoed in the yearbook, slightly mangled versions of names and so on, but often you just have to look at the plea roll for those. So in this case, the parties, the abductor, Roger the abductor, the geography, that's all in the plea roll and not the yearbook. The plea roll also is a place to go for legal process details, so the stages that the litigation has gone through, whether people haven't shown up, for example, who's holding the land now, who's present in person. In this case, actually, that's really quite interesting and useful because we learn something about the participation of the defendant, Joan Beecham. So in terms of gender, it's quite interesting. So this is not mentioned at all in the yearbook, but we learn from the plea roll that Joan Beecham had to make an application to be heard, to come in person, because her husband was being a bit inert and was defaulting. So if he didn't turn up, she was in danger of losing the land, which was her family land. There are also more details on the end result in the plea roll. So the yearbook is not interested in the end result. That's not its business. It's interested in what lawyers said, and the end result happens off somewhere else other than Westminster, so not interesting. So we find out that the Turringtons win and the Beauchamps lose their land, and also some financial penalties are imposed upon them. Legal representation is actually split between the two. So we learn about the attorneys, the kind of low-level people, representatives from the plea roll, but the sergeants and judges we learn about in the yearbook. So difference of focus again. In terms of the factual details, the action which is supposed to have taken place, the plea roll has some stuff in it that's not in the yearbook at all, even though it's quite exciting and interesting. So it's from the plea roll that we learn the business about Joan Turrington being, how the abduction went down, essentially. So we've got a rather dynamic picture of Joan Turrington from the yearbook. She is resisting, she's standing over her husband's body, and has to be treated quite violently to be overcome and taken away. And then she escapes as soon as she can once she's been taken off to Southwark. So in the yearbook she is much more passive, she's having things done to her, and she doesn't speak. So I think it's worth just reinforcing that in the yearbook the consequences get lost because the focus is on what's effectively a preliminary stage in proceedings. And it's worth saying at this point that what lawyers are trying to do is come to a single issue. This is a really important and perhaps slightly distorting fact, I think. The rules of the game are that you can't plead a whole load of things in the alternative. You have to rest upon your best point, if you like. The reason for that is you're only allowed to ask of the mode of proof, the jury type institution in this case, a straightforward kind of black and white yes/no question. So you can't ask them a whole load of different questions. You've got to have one question that you've agreed upon that goes out to proof. So that is something which kind of shapes the way that the story is told. The final thing to think about in terms of yearbook plea roll is the law itself. So in the plea roll we hear a lot about facts. The legal doctrine is in the background. Not surprisingly, given who has written it. In the yearbook the law is at the forefront. So in this case there's a lot of discussion of pleading rules and statutory interpretation. So very different focus in the two sets of records. I have in my notes here, people don't always tell the truth in legal proceedings, shocker. Well, I'm sure you know that. We know that just because something's written in a document and has survived, that doesn't mean it's true. I'm sure you're familiar with the important works on fiction in the archives and work on petitions, which show people bending their facts, presenting them and themselves so as to maximise their chances of achieving their ends. And that applies across the board in medieval studies. But I think common law records have some particular interests and particular nuances and complexities with regard to this whole truth question. And I wanted to give you just a few quick examples other than Turrington. There are a couple of three articles on there which I think illustrate quite nicely some of this. When I was preparing this talk, I had a word with various medievalists, and one of them, Sarah Butler, suggested a good point to make here for you, which was that although historians are certainly not gullible. They're not thinking that everything is true just because it's written in a record. And they're definitely on board with the whole the idea of people presenting themselves in ways that are going to be effective. Sometimes it's a little surprising to learn that there are fairly banal things, very simple and boring things, small things in legal records which might also be untrue. So it's not just the big flowery stories which you have to think about, it's also some smaller things as well. So for example, stories about self-defense which you come across in homicide records are very, very stereotyped. Somebody is always being caught in a corner. Somebody only draws their knife because they see that they're in danger of death. They strike a single blow. And if you look at one of these stories, you might think, yes, that could be what happened. But when you see that it comes up again and again, the same little phrases, you will begin to doubt whether that is in fact what's happened or whether something is being hidden behind a stereotyped story. And taking it down further, certain kinds of homicide cases, those brought by widows, frequently include the expression that somebody was killed inter brachiis sua. So the idea is that the woman is there physically present and her husband is dying in her arms or being killed in her arms. And the first time you see it, it looks like a pretty harrowing experience for her, until you realise that it's always said up to a certain point. It actually starts to die out around the time of Tyrrington, in fact. And it's doing a different job. It's not there because she was in fact physically present. It's putting her on the scene in order to justify giving her the right to bring this sort of action, the right to start a criminal prosecution. And the same is true with the thing at the bottom. So this is something, trespass viet armis, the expression viet armis, with force and with arms, is used in every single tort case in the 14th century, in the first half of the 14th century anyway. And one of the really groundbreaking pieces of work in sort of classical doctrinal legal history in the school of F.W. Maitland was that by S.F.C. Milsom in the 1950s, where he uncovered the fact that this was just something which was being said. So things were not being done forcibly and deliberately with armed force against the king's peace. And he uncovered many cases in which actually what was being alleged was blacksmiths were attacking horses, or carpenters were, I don't know, getting a bit violent with pieces of wood. And it seemed very unlikely, and his hypothesis was that this was something which you had to allege in order to bring your case to the royal court, rather than taking it elsewhere. And that seems to be a very robust finding. So the big point is, it's not just big flowery stories that you have to ask yourself about. It's little phrases which you need to, I suppose you need to see enough cases to be able to recognise when something has become a stereotyped formula which might not have a very close relationship with the truth. And let me just turn back to Tyrrington. What about the truth in that case? Well, even with the luxury of having both the plea roll and the yearbook, which allows some degree of correction or adjustment of one by reference to the other, we can't really know what's true. Was there a violent attack? Did Joan Tyrrington run off with a man, Roger? We can't even really know who spoke in court and whether they spoke as it was reported. It's almost certainly not true that that's all that was said. So we can throw some things out as hypothetical, the baby, as I say, but we can't be sure which of the two presentations of events surrounding Joan Tyrrington's leaving of her husband is closer to the truth. And this is because of the requirement of the specific legal provision, so the statutory provision in that case. So one side has to say you ran off with an adulterer and you stayed away. the other side has to negate at least one of those things. There's some argument about whether they have to negate both of them or not. And as I mentioned earlier on, a further kind of truth masking aspect of this procedure is the single issue rule. So there's no pleading in the alternative. You have to go with one version of events, and that obscures what was actually thought to be the truth. So for those of us who have detective inclinations, it's a bit unfortunate. There are not many cases in which we really can have any degree of certainty about what in fact happened. That, of course, shouldn't stop us. There's so much to learn from all of this. There is material to get in terms of intellectual argument, intellectual debate, what people thought was a plausible course of action or a plausible version of events is also very important. So just because we can't be sure about the truth, it doesn't mean that there's not a great deal that we can get out of these records. And I certainly find them extremely engaging and rewarding. We began with a 19th century legal treatise, which I believe in its zeal to strengthen an argument about contemporary legal rules, misrepresented or at least exaggerated the legal position in the 14th century. Doing this, misusing and distorting the legal past, was part of a long tradition, and it's one which still exists. One perhaps surprising feature of modern common law is that in theory, and sometimes in practice, all common law cases which haven't been explicitly disapproved are available in some way to be cited as precedents. Since the 19th century, the doctrine of precedent has hardened, so that yearbooks, documents which were somewhat discursive and certainly not treated as the last word in legal doctrine in their day, have come to be treated like modern authorities, as if they were created in the world of hierarchical courts with a set pattern of appeals, which we have today, and not the more pluralistic setup of their own time. You still see yearbook reports in modern law reports. Sometimes they're cited as a bit of colour, bit of showing off perhaps, but sometimes they remain important, foundational. For example, I remember being taught about an area of land law called covenants, and I will spare you the details of what that's about. But anyway, one of the cases cited as key to that area was the Priors case, 1368. All the references are up there. Modern lawyers cite it for a particular proposition to do with covenants, rights in land, and what they use it for is a bit of an exaggeration, but it's not wildly wrong. Maybe in this case it's not even especially damaging, but I remember not liking the fact that they were using it without any plausible claim to having read it. Since the report is in this ossified Anglo-Norman French, the record is in Latin, and I'm not sure that anybody before me had actually bothered to match the two things up. And I think that I found something rather offensive in that sort of uninformed citation. Perhaps it was even my first step on the road to specialising in legal history. And that's a fairly trivial example, I suppose. There is scope for the misinterpreted past to be used in a much more damaging way, as it was in some 19th century cases relating to women's legal personhood, or lack of it, in the move towards women's suffrage. So perhaps the last thing every medievalist should know is that the common law claims a long memory, but in fact it doesn't remember very well at all. So it's lucky that there's a huge pile of medieval notes to self left for our examination, not just by lawyers, not just by legal historians, but it's important that medievalists of all persuasions get stuck into them, I think. It might appear that it's all been done by Maitland, by the Selden Society, but for various reasons there's a lot of work to do, I think, on the existing corpus of common law records. Classical legal historians have not really been particularly open to the insights of historians or medievalists more generally, so I think that there are unplumbed depths for today's medievalists of all persuasions, and no need to be scared. Here comes the big finish. Or is there? Doodle of a lawyer vampire. Okay, I'm sorry that I've gone over the time limit a little bit, but got one more animation. Here it comes. It's now time to go to question and answers, and here is a tag sometimes seen in legal common law records, roughly translated, let's have a chat. Thank you.